How is everybody doing today? Listen, I'm excited to bring to you this month's podcast. It's July already. Can you believe it? The time is like flying by. And this month we're talking about Family Medical Leave Act, attendance policies, and the employees that can call out slick, as I like to call it. You know, they develop a cough or something similar in nature that could be relatively minor in terms of a sickness, but it tends to fall like around the holidays consistently, or it tends to be on the weekends, what I like to call the bookends of the weekend, Friday, Monday, you know? So we're talking about that this month for the podcast. My name is Stephanie Lomax. I am CEO and HR strategist for HR Pro for You, an HR consulting firm where we help businesses embrace HR. And I'm also your host for the podcast, HRInThe, which is a video podcast that exposes the dark side of HR, the stuff that people don't like to talk about. And often not talking about it means that it goes undiscussed, and going undiscussed in terms of HR could yield some really high, expensive court costs and things of that nature, lost time productivity. So we're going to lay it all out here in the podcast. So as I mentioned a few minutes ago, we're talking about FMLA, right? So what exactly is FMLA? What does it stand for? It's one of those acronyms in the alphabet soup of HR. And it stands for the Family Medical Leave Act. It was passed in 1993, and it was designed to provide job protection for employees that were out dealing with a number of very specific reasons, and I will read them to you. It is a Department of Labor law. Was passed under their jurisdiction, and it provides, the federal law provides up to 12 weeks of unpaid leave for an employee for the birth or adoption of a newborn, to care for an immediate family member, which would be a spouse, child, or parent that has a serious health condition, or to take medical leave when an employee is unable to work because of their own serious health condition. So some pretty specific reasons that are listed there. The most popular, most common, I would say, I guess, if I could say that, is probably the birth of a child or the adoption of a child or placement of a child into foster care or something of that nature. But obviously there's, you know, people that have illnesses that they're dealing with. And so the family medical leave also covers 12 weeks of unpaid job protection for them, whether it's their own serious health condition or whether that of an immediate family member, which was defined in the law as either a spouse, a child, or a parent. Employees have to have worked 12 consecutive months, and they have to have completed 1,250 hours of working hours within that 12-month period. Employers that are required to follow the law have to have 50 employees, at least 50 employees, and those 50 employees are required to be within a 75-mile radius of the main office. So for example, I'm here in the DC metropolitan area. So if I have a client who has 30 employees in Maryland, 15 in DC, and 20 in Virginia, that's certainly, well, depending upon what part of Virginia, let's say it's Northern Virginia, that certainly would be within a 75-mile radius. And so my client then would be required to follow Family Medical Leave Act on the federal side. What's important to also note is that there are several states that have miniature FMLA laws or mini FMLA. And so those are, just to throw out a few: California, we probably figured that, Connecticut, DC, Maine, Minnesota, Hawaii, New Jersey, Oregon, Rhode Island, and some others. So if you're not sure whether if you know for sure that you don't follow the federal or not required to follow the federal FMLA, but you're not sure whether your state requires it, make sure that you contact the State Department of Labor, and then also you can contact the Department of Labor, and they'll give you the list of states that have miniature FMLA laws. So what has to happen in terms of FMLA? Employers are required to notify employees that they may be eligible for this job protected leave under FMLA when they find out that the employee has a potential illness or maybe going to give birth or something like that. When that employee actually determines that it is possible they will be out, they get a medical certification that goes to their physician. Their physician completes the medical certification within 15 days of them getting the notice, and they return that medical notice within 15 days, and then it is reviewed to make sure that it does indeed qualify under Family Medical Leave Act, and then there are other things that have to happen as a result of that. We have to let them know what their rights are in terms of what happens while they're out on leave. They have to maintain their health insurance if they're enrolled in it. The employer is required to continue to pay their portion of those benefits, and you can work out the arrangements of how the employee is going to pay their portion of the benefits while they're out on leave, but they have to remain on the policy. When they return from leave, they have to be placed in the same or similar position that they were in before they left to go on leave. And we'll talk about why that is a big deal and what some people do as it relates to returning from leave in terms of the employer side. The other thing that's important is that those 12 weeks, or if you're in a state that has more generous, i.e. DC has 16 weeks, that leave does not have to all be taken at one time. It can be taken intermittently. So if an employee has doctor's appointments that they have to go to after they've been medically certified that they need to be seen by a doctor or a physician because of their condition, then that leave can be taken. So if they take 4 hours off during the course of the day to go to a doctor's appointment, that 4 hours would count against the 12 weeks or the 16 weeks or what have you of leave that FMLA provides. So it's some record tracking and attendance tracking that has to happen with FMLA, which can get a little bit tricky. And these are compliance things that have to be followed to a T. So what happens if an employee doesn't return the paperwork from the physician within 15 days? The employer has the right to deny their family medical leave. So that means if they do decide to take off work, that they are no longer protected under FMLA. We're not required to hold their job. And if they have to be off for an extended period of time, but they did not turn that paperwork in and it becomes an undue hardship to keep that position open, we can fill that position if they're not there. So it's really important that both the employer understand the timeline and the employee understand the obligation of getting that paperwork back in time so that all the compliance things are met. Speaking of compliance, let's talk about the 5 biggest compliance mistakes under the Family Medical Leave Act. And I will read them to you so you can make sure that I get you the information as it is written. Number 1, taking adverse action against an employee returning from FMLA. So I just finished explaining a second ago that when an employee comes back from FMLA, they are required to be placed in a same or similar position that they were in prior to taking the leave, which means that if an employee was a staff accountant and they were making $45,000 a year and they worked full-time and they were eligible for full-time benefits as a full-time employee, when they return from leave, they should be a staff accountant making $45,000 as a full-time employee with benefit eligibility. They cannot be, it's advisable that they're not, their position isn't changed, that their duties are not changed, that their pay is not changed, that their leave benefit status is not changed as a result of them coming back. We also have to make sure we're not firing someone that's coming back off of FMLA. Does it mean that a position change cannot happen to someone when they return, or that if a person is under disciplinary action and something happens upon returning that will cause us to exercise termination, that we cannot? No, it does not mean that. What it does mean is that we need to be aware that it could look like adverse action and that we are retaliating against them for having been gone. So we better have some documentation and be very clear and speak with an HR consultant if you don't have in-house, or an employment attorney, to make sure that you're crossing all of your T's and dotting all your I's properly when someone is returning from leave and you plan to exercise adverse action. Number 2, saying the wrong things when an employee requests FMLA. Oh, you're not eligible for that. Oh, that doesn't qualify. How do you know? They haven't even filled out the medical certification information yet. Okay, you can't really say that. So the best thing to do is to provide them with the paperwork, let them know they may be eligible. However, they have 15 days to get that documentation certified by a medical provider, bring that information back, and then we determine whether or not the leave actually follows the guidelines under FMLA and whether it actually qualifies for the leave or not. Assuming that minor ailments don't qualify for FMLA. Somebody has, bronchitis that is habitual. It just continues to show up, every fall or spring or something like that. We don't know whether that would qualify under FMLA. We need to know that, and we're not physicians. That's not our job in HR or the employer, the CEO, the supervisor. Not unless we really do work in the medical field. We still have to have that medical certification done. And if you do work in the medical field, it can't be you that certifies it. So how about that? So we want to make sure that information gets to the employee's physician and that it is certified properly, so that we can make sure that if it is a minor, what we would consider to be a minor ailment, that we're not passing judgment on whether what's considered minor and what's not considered minor. Number 4, disclosing a worker's private medical information. There is a huge compliance risk when we talk about personal health information, PHI. And so this type of information, FMLA paperwork, medical certifications, doctor's notes, follow-up notes, etc., that all qualifies under what's considered private health, personal health information or private medical information that cannot be disclosed to anyone else. So coworkers that come to find out, why is Beth out so long? What's going on with her? Yeah, none of their business unless Beth tells them directly. It does not come out of the employer's mouth, it does not come out of the supervisor's mouth, and it better not come out of HR's mouth or I'm going to come and get them. So we want to make sure that we keep that information under wraps. And it should also not be kept in the employee's personnel file. It should be in their benefits file, which is a separate file altogether anyway, because that information doesn't need to be disclosed to anybody in any case. And then lastly, penalizing employees for unforeseeable FMLA. So somebody goes out and they get into a car accident, they're a tax accountant. Well, I'm picking on accountants today, but they're a tax accountant, it's tax season, they go out on FMLA because they got into a car accident. Yeah, and then we terminate them or we penalize them, we demote them, we do something to them adversely as a result of them being out. It's our busy tax season, we're down a tax accountant. That stinks, I'm sure. We cannot do that. That is a compliance risk. They can sue, they can likely win, meaning the employee can likely win. So we want to be very, very careful about that. How do we determine a serious health condition? We don't, okay? The medical certification does. However, it would be safe to assume that if a person is out for more than 3 consecutive days, 72 hours, that they may have a serious health condition. The flu, therefore, could possibly qualify as a serious health condition. So we need to be aware of that. Once again, we are not the judge and jury on the medical certification in terms of what qualifies. What we are required to do is provide them with the medical documentation, have that information come back from the medical professional, and then review that information to make sure it follows the guidelines and qualifies. What happens if an employee is out on this Friday, Monday, slick day, the weekend bookends, like I like to call them, and they do it consistently? Will they qualify for FMLA? The problem is it's not consecutive days, right? So Friday is one day, the weekend doesn't count, Monday is yet another day. So now what we have is a consistency problem in terms of attendance, and we need to make sure that our attendance policy is tight around how we expect employees to behave and report to work on a consistent basis, and that consistent absences that follow a pattern, i.e. weekend bookends, could be a disciplinary action up to and including termination. That's what the attendance policy needs to say. So let's talk about, I always have a case, right, to discuss. So we have the case of Douglas Rydalk, who sued Southwest Airlines. We all know them, right? They've been around for a long time, very popular airline. He was hired back in 1998 as a sales agent at the desk, and he worked in Utah, where his hometown was. In 2004, he was transferred to Houston because Southwest closed their Utah sales agent desk area, and they transferred him to Houston, Texas in 2004. In 2004, after he was transferred, he was in a very serious car accident that caused him a back injury. The Southwest Airlines HR gave him paperwork, got certified by a medical professional for FMLA. He was out for X number of days over a period of time that fell within the guidelines of FMLA. They granted him the FMLA to take, and he continued to go through therapy and things like that. However, in 2007, they noticed a pattern that Doug would take leave on bookends and around the holidays, and go figure around his birthday also. They just noticed this consistent pattern of him calling out because his back was flaring up. What we realized in the case, as I was reading it, what Southwest Airlines realized was that because Doug had not been working there that long, he'd been there for 6 years, but their seniority policy in terms of who can take leave when, he wasn't able to get off a lot of the holidays like others were. So these flare-ups from this car accident, after they, God forbid, moved him and relocated him to another city, his family was still in Utah, he's living in Houston, and they found out that when he was out on leave for FMLA, that he was flying back to Utah when he was supposed to be, home breasting his back injury. And so once they discovered that, this is 2007, to a tune of 35 times he did this, at least 35 times, okay, over the course of a few years. So his last stunt he pulled was around Christmas. He was off for the Christmas holiday, and his back flared up, go figure, during Christmas, and he took off the 26th and 27th, and they terminated him at that point for violating not only their attendance policy, but also abusing FMLA. And he sued them, go figure, he sued them because he said that they were penalizing him because he was on FMLA. Well, the court took one look at the documentation that the supervisor had provided and the tracking that they had done, which they had done an impeccable job of his attendance records, and they also came to the same conclusion that Mr. Doug was taking off time and abusing FMLA, or under the premise of FMLA, but he was actually not out on FMLA, didn't have certified medical certifications to justify it. While they were consecutive days, he was definitely abusing FMLA and violating the attendance policy under Southwest Airlines, and the court tossed the court case out, just like Southwest tossed his job out with him onto the street. So what's important to know in terms of the attendance policy and FMLA and compliance? We want to make sure that we keep accurate records of attendance. That really is the biggest thing, because if we don't have records that say this is when a person was absent, or this is how many hours they took under FMLA over the course of the 12 months, we really don't have a leg to stand on if in the event we need to exercise some type of adverse action when a person comes back from FMLA, or if we recognize that they're abusing FMLA and they're violating our attendance policy, assuming we have one written. So we want to make sure that the attendance policy is clearly documented, that we follow the guidelines. Specifically, it is really important to make sure that 15-day guideline is followed, so that when we put an employee on notice that they may be eligible, they've got 15 days. If they don't do it within 15 days and they come back day 21 and say, here's the paperwork because I need to be out, guess what? Nope. It's not going to happen. So we need to make sure that those guidelines are followed, those deadlines are followed, and that the attendance policy is written and tightened in the event that these consecutive absences or frequent absences don't really qualify for FMLA. That is this month's video podcast. Hope it was short and sweet, packed full of information for you. If you have not already subscribed to the podcast, you can do so right now by following, going to the website, which is www.HRPro4YOU.com. And you can subscribe there. You can also catch prior episodes there on the website, and also learn more about what we do for our clients and services that we provide to our clients. So we would love to have you do that. Next month, I have a surprise. What is the surprise? I don't know yet, but it's going to be something good. So make sure that you follow me on social media. I'm on LinkedIn and Twitter, and also on YouTube under HR Pro, the number 4 YOU. And I'll drop what we're going to do for next month's podcast as soon as I figure out what that excellent, stupendous, fantabulous surprise in terms of HR in the dark topic is going to be for you. Until then, hope you have a wonderful, wonderful month of July. Enjoy this weather wherever you are. Make sure you get some family time in, and I will see you next month. Have a good one.